Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the recently announced suspension of U.S. immigration announced by President Trump and the implications of this with respect to those who are looking to file for a visa. So most of the cases we deal with here in Bangkok are family-based cases. So we're dealing with fiancé visas, marriage visas, stepchildren visas, visas for children for whom their citizenship to the United States was not automatically conferred, perhaps by the U.S. citizen parent, and children of lawful permanent residents. We see a lot of these cases, so family-based immigration. The recent announcement that certain immigration would be, well, it seems to be rather general, and let me be clear and preface the rest of this video. We're making this before the executive order has actually been promulgated. It's after Trump announced it, but we've yet to actually see the terms or the actual written document of the executive order itself, so that remains to be seen. So as of the time of this video, we don't yet know exactly what's at issue here. I'm going to read a quote soon, but first I just want to talk conceptually about the difference between a visa being issued and a visa being sought. So notwithstanding the fact that Trump may have placed a moratorium on the issuance of, in this case, immigrant visas that might confer a green card or lawful permanent residence, or has placed a moratorium on those adjusting to immigrant status in the United States or adjusting to what's called lawful permanent residence, it does not necessarily mean that a case cannot be filed. And in fact, notwithstanding the fact I haven't seen the executive order, I'm fairly confident in stating that I expect it will still be possible to file those kind of cases. One, I don't think that they can preclude petitioning for anything. Now they can deny or delay it, but you can ask, in sort of a conceptual sense. You can always ask the question, can this person come to the United States? Can we get a green card for this person? But that doesn't necessarily mean they're going to do it. They may delay it or they could deny it. But it doesn't preclude asking for it. So I think it's still definitely possible cases will be filed, and clearly approvable cases I don't necessarily think will be adversely impacted by this much past delay. I think delay may be the worst. For example, if somebody's seeking an immigrant spouse visa, an IR1 visa, for example, they're wanting to bring their spouse back from Thailand amidst this COVID-19 issue, and they want to go ahead and petition for that immigrant visa benefit. I think it's still going to be possible, even after this executive order comes online, to file that case. But if you were coming up for interview, this executive order may preclude that case from seeing its visa issued. Now, that's stated in a recent article from the, recent article from the Daily Wire. The Daily Wire. That's dailywire.com. Article is titled, "Trump Says Immigration Freeze Will Last 2 Months, Reveals New Details." Quoting further, according to Politico, a source, quote-unquote, familiar with the situation indicated that the executive order will not apply to healthcare workers seeking green cards or people with nuclear family members, quote-unquote, inside the United States. So that could be an American spouse inside the United States petitioning for example, a Thai spouse here out of Bangkok. Quoting further, "The specifics of the nuclear family exemption are unclear. The New York Times reports," and they're quoting the New York Times now, "American citizens seeking to bring their children or spouses to the United States would still be allowed to do so, which suggests that the exemption could be limited to them." So, remains to be seen how fiancés are going to get treated by this. I think fiancés may end up threading the needle, if you will, insofar as the policy seems geared toward employment-based immigration. It seems that family-based immigration, at least nuclear family-based immigration, is going to be exempted under this. And to be clear, a K-1 visa does not confer a green card. A K-1 visa is actually a non-immigrant visa, technically, notwithstanding the fact it's what's called a dual intent visa, and allows the visa holder to travel to the United States with the intention of immigrating after getting married and applying for adjustment of status. So I think, again, as of the time of this video, that the K-1 is going to kind of thread the needle and not be adversely impacted by this announcement. Remains to be seen, and we will certainly update this channel as things progress. But for now, the thing to take away from this video is, yes, I believe we can still file cases notwithstanding this recent executive order. And it remains to be seen whether this executive order isn't enjoined. The courts may, and I'll do another video on that actually, the courts may decide to enjoin this executive order and say, look, we don't agree with this, and basically forestall the president from, and more importantly, the agencies associated with immigration from enacting this order. Again, that remains to be seen, and the order actually has to be promulgated in order for an injunction to be filed, and ultimately, if it's approved by a judge, enforced to enforce an injunction. Again, all of that remains to be seen. The thing to take away from this video, notwithstanding this announcement, I do think it's still going to be possible to continue to file a petition, especially for family-based immigration benefits moving forward.